Hello everyone. So this is a video about mens rea, or criminal fault, as we could also call it. So some faults are objective. It doesn't matter what the defendant believed, but what would a reasonable person believe in that case. So the person could be culpable even if he didn't think he was doing anything wrong. So regardless of his state of mind. For example, supposing somebody's playing cricket in a garden near a greenhouse, the ball smashes the window. Now, the people playing cricket, they didn't wish to smash the window of the greenhouse, but they would have presumably accept that they were running a risk that the ball would go astray and smash that window. If someone else took that cricket ball and deliberately threw it at the greenhouse with the expressed aim of breaking the pane of glass, that would have had the same effect. But so whether you're reckless or whether you're doing it intentionally can both give rise to criminal fault. Okay, so that's what objective fault is about. So some people think that objective fault is unfair. Take that example I got, the people playing cricket. Well, there was no malice in them, but nevertheless, they could be held liable for criminal damage. In reality, these situations are usually cleared up outside the criminal law. Apologise, pay compensation, whatever it is. So McCrone Riding 1938 is a case about this. So someone's driving dangerously, supposedly carelessly. Now, this person was a learner driver, but nonetheless he was held to the same standard that you would hold someone who'd already passed his test and was experienced on the road. So there's a celebrated book by Punishment and Responsibility by a well-known scholar of jurisprudence, the late H.L.A. Hart. It was part of a long-running debate, a multi-decennial debate in jurisprudence. I shan't go into it. An Oxford professor, and he said people deserve to be punished for not reaching the standard of behaviour that is required of them, but the punishment should be limited to those who could have behaved properly if they'd tried to. This is what he said. What is crucial is that those whom we punish should have had, when they acted, the normal capacities, physical and mental, for doing what the law requires and abstaining from what it forbids, and a fair opportunity to exercise these capacities. That's the end of the quotation. Let's look now at subjective fault. So there are usually crimes have a subjective fault element. Now, there are exceptions, for instance, rape and gross negligence, manslaughter. So most of these crimes have a long sentence attached to them. So citizens are to be protected from unfair incarceration, usually when they're doing something, when the wrongdoing doesn't have the bad attitude. Okay, so it's the mental element which makes you culpable, and that's why you are penalised. So anyway, you get what you deserve. That's the idea. The punishment should fit the crime, as Sir William Schwenk Gilbert wrote. So defendants must be aware of the wrongdoing that he is guilty of. So if there's objective fault, he doesn't need to be aware that he's doing something wrong. Remember, ignorantia lex non excusat. So the defendant is still culpable because he did something wrong, even if he didn't realise it, even didn't intend to, or so on, just because he was foolish, even wasn't conscious of any wrongdoing. So there are subjective mental attitudes of different kinds. For murder, the prosecution has to prove that someone intended to kill or cause serious injury. If the action intended to cause serious injury went so far as to actually kill the person, that the defendant didn't intend to kill the person, nevertheless, the defendant's guilty of murder. In the case of theft, the prosecution must demonstrate that the defendant tried to deprive someone of his or her property. Coming on to criminal damage, here the prosecution must convince the court that the damage was done purposively or else recklessly, but there must be some foresight of the damage which could arise. In the case of handling stolen goods, or receiving, as we sometimes call it, the prosecution must persuade the court that the handler knew the goods were stolen or believed them to be stolen. Wasn't certain, but believed them to be stolen. Okay, so we're going to look on this mens rea, the subjective fault. We're going to look at intention and recklessness, which is what objective fault is usually about. There's also negligence. Right, so here there's intention, or what you wish to do, what you're trying to accomplish. And this is central to criminal liability. So this is the fundamental element in core crimes. The defendant wished to perform an act, and that was the criminous wrongdoing. If you wanted to kill someone, wanted to shoot somebody, and the prosecution has to prove that the defendant intended to pull the trigger and intended to kill someone, or indeed cause a serious injury, not intending to shoot in the air, intending to scare, intending to miss, that's different. So intention is different from motive. So a motive is the reason that you're doing the thing, but in criminal liability, motive is not to be considered. So there's basic intent and specific intent. And so crimes can only be committed with an intention, and that's the fault element. So these are crimes of specific intent. Certain crimes can only be committed with intention. A crime of specific intent is one where the prosecution needs to show that the defendant intended to cause something to happen. This is specific intent. Okay, as in murder, you intend to kill someone or to cause grievous bodily harm. So the prosecution has to convince the court that that was the defendant's state of mind. There are crimes which do not need the prosecution to prove there was an intention to cause any outcome. These are crimes of basic intent. Criminal damage was one of these. The prosecution needs to show that the defendant intended to start a fire, to throw a stone, to fire a gun, and so forth. They don't need to prove that the defendant intended the damage to result. He might foresee that such damage might follow from his action, but he doesn't have to be convinced that it will certainly follow from his action. Let's look at manslaughter and murder. So what's intention here? Anyway, we know that obviously if you intend to kill someone, that can be murder. And this is different from manslaughter, where you don't need to demonstrate such an intention as a prosecutor. Hyam against DPP, 1975 is a case. The House of Lords had to look at this when was Hyam guilty of murder or manslaughter? Well, Miss Hyam had put a petrol bomb through the letterbox of another house where Miss Booth lived. Nice lady, Miss Hyam. And Miss Booth was slumbering at the time. Now, Miss Hyam said, "But I didn't want to kill Miss Booth. I just wanted to terrify her so she'd leave, because I had fallen head over heels in love with Mrs. Booth's husband." Well, in the best laid plans of mice and men gang aft awry, as Robbie Burns wrote, because it didn't kill Mrs. Booth, and might have frightened her, but it did kill Mrs. Booth's 3 children, which I don't suppose endeared Miss Hyam to Mr. Booth. Anyway, so Miss Hyam was found guilty of murder, despite her not wishing to actually kill anyone. She behaved in a way, she was reckless to what was happened. She knew there's a considerable chance that people would die as a result of her setting the house on fire. Okay, there was Maloney, 1985, another case. There's Hancock and Shanklin, 1986. So the House of Lords looked at what intention is all about. Their conclusions are valid for different kinds of cases. The House of Lords later overruled Hyam, said if it can be shown that the defendant realised that there was a probable consequence but carried on anyway, that does not automatically prove that the defendant wanted the consequence. I mean, as in Miss Hyam wanted the children to be killed in the fire. But if the prosecution can show that the defendant acted with foresight, then this is evidence that the consequence was intended by the defendant. So why else would the defendant carry on acting that way? So in most cases, the only evidence that the defendant intended to do something is that it was likely to follow from the defendant's action. So the higher the chance that it was foreseen by the defendant, the more likely it was that the defendant actually wanted this harm to occur. Because why would a defendant continue in this action if he or she didn't want that consequence to follow, as in people to die in the fire? So the evidence shows that the defendant foresaw the result as almost certain. Then the inference is drawn that the defendant intended this consequence to follow. Nedrick, 1986, is like that. It's a case which is almost the same as Hyam. And Lord Lane, who was Chief Justice at the time, said this: where a man realises that for all practical purposes, inevitable that his actions result in the death or serious harm, the inference may be irresistible that he intended the result, however little he may have desired or wished it to happen. close quotation. So the jury have to decide if the result of the action, as in people dying in a fire, for example, were intended, and they have to take into account all the evidence, not just how likely this result was to happen. So Section 8 of the Criminal Justice Act 1967 says this about the jury: they shall not be bound in law to infer he intended or foresaw the result of his actions by reason only of it being a natural and probable consequence of his actions. Close quotation. So not bound to find that, but they still can find that. They are allowed to find that. So what the jury ought to do is make a decision about whether D wanted this to happen or indeed had foresight that it was likely to happen. And the Act goes on by reference to all the evidence, drawing such inferences from the evidence as appear proper in the circumstances. Close quotation. So some people think that Nedrick means that if a person acts knowing that an outcome is almost definitely going to happen, then that's by a matter of definition. That he intended it. However, that's wrong. Okay, the jury will usually find it hard to avoid concluding that the defendant intended the consequence in such a case, even if that's not the defendant's primary aim, as in Miss Hyam didn't actually want to burn the 3 children to death. Okay, so I got to... Anyway, carrying on a little bit. So what's the House of Lords been saying about this since? There was a case of Woolen in 1999 in which the House of Lords said the approach taken in Nedrick was correct. So in Nedrick, this man threw his baby son across the room when he was irate, and the boy suffered a fractured skull and died as a result. So Woolen was charged with murder. The prosecution said, okay, we acknowledge that Woolen didn't actually want to kill or cause serious injury. However, he at least caused some injury. So Woolen was convicted of murder. He appealed, said that the trial judge had erred in law. He'd misdirected the jury about intention. The House of Lords drew 2 key conclusions. This is the doctrines arising from Woolen. In most cases, the jury should not be directed by the judge as what intention is, because everybody knows what intention is. The jury should only be told they should find the defendant not guilty of murder unless it's sure that he intended to kill or to cause grievous bodily harm. Anyway, it must be explained to the jury that intention and motive are not the same thing. Intention is what you want to happen, whether you want the child to die or not. And motive, why are you doing it? Because you're very angry? Because you think it's fun? Or what? So motive and intention are different. The other thing to emerge from that case is the jury need to be given guidance in unusual cases, for example, Woolen, where the evidence doesn't show that the intention was to kill or cause grievous bodily harm, but it shows the defendant knew that death or grievous bodily harm could follow as a result of what the defendant did. And that's what the guidance in Woolen is about. So this is the model direction which a jury from which judges shouldn't swerve. And this is it. Where the charge is murder, and in rare cases where the simple intention is not enough, the jury should be directed that they are not entitled to find the necessary intention unless they feel sure that death or serious harm was a virtual certainty, barring some unforeseen intervention, as a result of the defendant's action. And the defendant appreciated that this was the case. The decision is one for the jury to be reached upon consideration of all the evidence. Close quotation. So this direction makes it plain that seeing an outcome as almost certain is not intention itself. However, it suggests that the jury can infer such an intention, but of course that is depending on all the evidence available. Matthews et al. In 2003 is a case about that. So the jury could find that the death of the victim was intended. But they'd be less likely to find such a case where to find that the death of the victim was intended if the defendant couldn't see death as almost certainly following on from what he did. Okay, so the Woolen direction shows us the jury is entitled to say yes to cases where it's quite likely that the victim's going to die from what the defendant did, that yes, it was the defendant's intention to kill. But it has to make this decision based on all of the evidence there. So the jury is entitled to say no if they think that the evidence leads them to the opposite conclusion. So the will and direction is crucial because it gives jury amount of discretion, and they don't have to find the guilty in this cases where death occurs as a byproduct of an action. Okay, so perhaps this is odd. Remember, motive is not meant to matter here. Quite difficult, hey? So the will and direction is critical because it draws a line between intention and recklessness. Intention is actually wanting something to happen. Recklessness is accepting that it might happen, not caring whether it happens or not, but whether it happens or not, but just going ahead anyway with that dangerous action. So foresight is not certainty that something will happen, but realize it's a considerable possibility. So a brief restatement of the present law was set out by the Law Commission report. A person is taken to intend a result if he or she acts in order to bring it about. In the cases where a judge believes that the justice is not done unless an expanded understanding of intention is given, the jury should be directed as follows. An intention to bring about a certain result may be found if it's shown the defendant thought that the result was a virtually certain consequence of his action. Close quotation. So that's from Murder, Manslaughter and Infanticide 2006. The Law Commission produces these reports, these notes for guidance every so often. So we know what intention is. Okay, it's a common English word, and there's a book about this, Intention, Agency, and Criminal Liability. So in that book, it says that the direct intention is a state of mind someone would have if he's doing something with intention of something actually happening. Intention is understood to mean having a direct or oblique intention. That's the definition of the Common Law Commission. Okay, complicated, I know, but there we are. That's a little bit of intention. Toodaloo.